Western Cape Judge President John Hlophe launching that two-part urgent application at the High Court sitting in Johannesburg. He wants to interdict President Cyril Ramaphosa from suspending him and the National Assembly from instituting impeachment proceedings. Hlophe argues that the Judicial Service Commission meeting that recommended his impeachment was not properly constituted and should therefore be declared unlawful. Well, Zikhona Ndlebe is from Judges Matters, and she says there's a good chance that the case could drag on longer than the 13 years that it's taken so far. She joins us now via our video link from Cape Town. And Zikhona, I don't know if we have that time, but perhaps we're here nonetheless, and we should deal with the ramifications. The argument that John Hlophe is making is an interesting one. He's saying that the meeting that essentially came out with the outcome that he should be impeached wasn't even properly constituted. If he's right, what are the implications?
Well, he says that that meeting was not properly constituted because there was no Chief Justice, and Justice Kambembe was neither a Chief Justice or an acting Chief Justice. And he also says that there were no representatives of the attorney's profession. But now, if you look at the JSC Act says that in Section 2, even if the JSC is not properly constituted, any decisions that are made by the JSC are valid. But now Judge President Hlophe says that he is aware of that section of the JSC Act, but further argument will be made when the matter is heard at the High Court in relation to that. So he does not disclose what kind of argument will be made in respect of that, but we'll have to wait and see what argument will be presented on his behalf when the matter is argued in court. So that's basically what he's saying in respect of the proper constitution of the JSC. And the impact the impact will depend on the findings of the court, because we've got the JSC Act, which says that any decisions that are made, regardless of who is present, if the JSC is constituted or is meeting, those decisions are valid.
And it's not the first time that he's kind of had to deal with outcomes from the JSC. I think it was in 2009, the JSC actually finding him not guilty, that decision being revised, and now there's this fresh litigation, for lack of a better term. This back and forth, how do we factor that into the arguments he's making now?
Well, one of the questions that he raises basically is that in 2009 he was found not guilty. So he's questioning what has changed in terms of the facts that have been considered by the JSC that have now led to him being found guilty. So that's going to require a lot of consideration and scrutiny of the actual facts by the High Court judge that will be considering the matter. But that's going to it might take time, but in his papers, he has requested that the JSC provides the registrar of the High Court with all the documents. And you must also note that it has been 13 years, so that means that it's going to be a lot of work that must be conducted by the judge dealing with the matter.
And that's why you think this will take an incredibly long time, because of the sheer volume of documents that these judges have to go through.
It is that, but not only that, because we must also remember that we've got a very lengthy legal system in our country. So it's the High Court that's going to consider the matter. And if one of the parties are not happy, then they will request an appeal. And if they are granted the right to appeal, the matter will be appealed to the different courts, which is the Supreme Court of Appeal, the Constitutional Court. So there is a possibility that the matter will go all the way to the Constitutional Court. And then you must also remember that if a matter goes all the way, it's going to take years. It's not going to be something that's going to happen overnight. Although this matter, the High Court matter, has been brought on an urgent basis, but there's also the potential of the matter dragging on because of the appeal process. Let's
speak about what's at stake with that protracted process in mind. I mean, this is a judge who's essentially being accused of undue interference with matters pertaining to the former president, Jacob Zuma. How does he preside over anything else with those kind of questions hanging over his head?
Well, this goes back to the issue of suspension of Judge President Hlophe, which he is fighting against in his court papers. So we would have expected that the JSC would advise the President to suspend Judge President Hlophe pending the finalization of the National Assembly process. But now, because he has instituted these proceedings, the suspension might be brought to a halt, because at the end of the day, if there is a contestation of the JSC findings, which is basically the High Court application, the suspension will have to come to a halt, and the National Assembly process will also have to come to a halt until the High Court makes a decision based on what Judge President Hlophe has said on the papers. But now we must also await the JSC's response to Judge President Hlophe's papers. But now, again, going back to your question, the impact of this is that we've seen in the past that there have been a lot of punches that have been thrown at the judiciary. And if this goes on for longer, there will still be a lot of controversy within the judiciary, and the public perspective of the integrity of the judiciary will also be at stake. So that's the main problem, because we've got people who are in high places, the Judge President and the National Assembly, the President, they're all involved in this, and then the Speaker of the National Assembly, because they've been cited. So it also goes back to the confidence of the judiciary and the perception of how the perception of the judiciary as a whole by the public.
And you speak about the perception of the public. We know that the public has been watching quite eagerly as the JSC conducted those interviews, for lack of a better term, in order to fill vacancies in the Constitutional Court. They've been sent back to the drawing board and essentially have to start again. I think it's sometime in October. How do they get that process right in the context where there are these questions around their perception, their legitimacy, and in some quarters of society, even their own integrity?
It's a very big problem, Ayanda. So in October, so let's start with the settlement agreement by the High Court. So there's a settlement agreement saying that the Constitutional Court interviews must be started afresh. But now the October interviews are not in respect of that settlement agreement or the April Constitutional Court interviews. It's for two vacancies that are already there. So it's the JSC interviews that will be taking place. There is no date set yet for the Constitutional Court interviews that took place in April to be rerun, basically. Right. So we are hoping that the JSC will set a date to rerun those interviews in terms of the settlement agreement. But that has not happened yet. But now the problem also goes back to the issue of criteria, because there's a settlement agreement, but there is no criteria that is set. So the question is, these interviews are going to be rerun again, but how can we be sure that the same mistakes will not be made? There's nothing in place to ensure that. So what we've been saying is that there needs to be a set criteria that is implemented by the JSC. It has to be in black and white, and everyone, the general public, must know about it, the legal profession must know about it, so that we prevent any other mistakes being done by the JSC and a possibility of the public, of organizations going to court and contesting the JSC interviews and the nomination of candidates, which is what has happened now.
Yeah. You know, the two links between the matter pertaining to the possible impeachment of the Judge President Hlophe as well as the rerunning of the JSC interviews is that there's this ongoing question around what is and isn't reasonable to ask. It's interesting to note how Hlophe, in his own arguments, is saying that no proper cross-examination had actually taken place in the lead-up to him being possibly impeached, in the lead-up to that recommendation, whilst the hearings also were grappling with what reasonably can be asked to the different candidates. Legally speaking, who gets to decide what reasonable probing and cross-examination even looks like?
So what Judge President Hlophe is basically saying is that in the JCT proceedings, his evidence was not properly considered. But now that means that the High Court is going to have to look at the JCT proceedings and then look at whether the JSC just rubber-stamped the decision of the JCT. But when it comes to how the JCT was supposed to be conducted, well, it had a chair, so and the JCT had well, the people that were in the JCT were supposed to ensure that everything is run properly. But that is, whether that happened or not is something that will have to be determined by the judge sitting in the High Court and dealing with the matter. And then going back to the JSC interviews of judges, the JSC needs to make a decision which is to ensure that there's a criteria. It is all up to the JSC, and we as civil society have been saying that it's simple. You just perhaps go back to the Mohammed guidelines, because there are guidelines that have been in place, that are in place, and that they've been in place for years, but those are not being applied by the JSC. So if for anything, use the Mohammed guidelines and then Section 174 of the Constitution and put those together. And then also perhaps look at Section 9 of the Constitution to ensure that there is equality when the JSC conducts interviews. And if you put those three things together, you will get a criteria. It's not that difficult. And this is what we've been saying as civil society, but it just needs to be in black and white, and it has to come from the JSC, with assistance from civil society if that's necessary.
Right. Zikhona, you and I have been speaking about the JST, the JSC, the National Assembly. All of this can get quite convoluted. Why should ordinary South Africans care what the outcome of this prolonged case actually is?
Well, they should care because judges dispense the law, and if an ordinary person is in dealing with the law or appears in court, it will be a judge that makes the final decision relating to a case that is brought by an ordinary person. So we need to ensure that we've got judges that are in good standing and judges that are capable to dispense the law. And in ensuring that, this matter has to be finalized so that the public will have a confidence in the judiciary at the end of the day, which is very important.
That's what it comes down to. Are the people making the decisions in our courts people who are above reproach? Thanks very much indeed for breaking it down for us. Really do appreciate your time. That is Zikhona Ndlebe. She's with Judges Matters, and according to her, we are nowhere near seeing the end of this case. Zikhona, once again, thanks very much indeed.